Hello, and welcome to this lecture on law, ideology, and human rights violations. I'm going to talk about the Western legal tradition and the dual state in this lecture. This lecture is the first one of 4 lectures covering 1 hour each, or approximately 1 hour each, where I'll talk about the Western legal tradition and the dual state. In the next lecture, I'll talk about law under Nazi Germany. And then there will be 2 lectures more, one on law and the Soviet Revolution and a comparison between the Soviet or the communist approach to law and the Nazi approach to law. And the final lecture on judicial resistance. So let's start now to look at the Western legal tradition and the dual state. The Western legal tradition is the legal orders that we are accustomed to here in Western Europe, the United States, and in many countries around the world that build their legal traditions upon the European Western legal tradition. We used to see this as a result of the Enlightenment, the French Revolution, the American Revolution, and the Human Rights Revolution after World War II. And we used to seeing this as a specific legal tradition with emphasis on individual human rights, rule of law, and democracy. We are proud to look at this tradition as a way of governing that protects the population from the excesses of an authoritarian or autocratic state or rulers. And this is, of course, in many ways true. The Western legal tradition is connected to democracy and human rights around the world today. And most of the democratic states in the world, according to different types of measures, are also states that are embedded in this Western legal tradition. The Western legal tradition, however, the way I see it, goes further back than the Enlightenment and the French Revolution. And we can say that it goes all the way back to the Middle Ages. And the conflicts between the kings and the nobility at that time, and between the kings, emperors, and the Pope. And many historians claim that the type of management that developed at this time, the type of law that developed, is part of the explanation of the economic success of the West after the 16th and 17th century. Because at this time then, in the 11th and 12th centuries, a particular way of organizing law and politics developed, where there was a recognition that the power in the state was bound by law, and there was the development of a notion of individual rights. This does not mean, of course, that we from these times have had legal institutions that have bound power, that we have had no autocratic or absolute powers in Europe since that time. On the contrary, of course, we have had that in many instances. And it does not mean either that individual rights have been recognized throughout this period. So that is not the claim of these historians. But the claim is that a particular way of understanding law developed at this time. The understanding that the power of the king is not unbound. The king must rule through law, but the king is also subject to a higher law, either to contracts with the nobility, as the Magna Carta in England in the 13th century, beginning of the 13th century, or as in the agreement between the Pope and the German Roman emperors, resulting from the conflict between the emperor and the Pope on who was to have the right to empower bishops within the church. In both these cases, a notion developed that the worldly power, the power of the king, was bound by a higher law. So the king ruled by law, but was also bound by law. The Magna Carta was only one of many types of documents that were enacted at this time. Now, what are sort of the basic elements of this Western legal tradition that developed at this time? Well, the basic elements were the principle of legality, that rules should be undertaken by law, by general provisions enacted before the exercise of power. This gave a type of legal certainty of great importance to commerce and to business enterprises. It was a prohibition of the arbitrariness of the executive powers and the control of these executive powers under independent and impartial courts by exercising effective judicial review, developing also into the respect for fundamental rights. And also the notion of equality before the law. All men are equal. Of course, as you know, these different elements of the Western legal tradition developed through the centuries to the type of understanding of law that we have today after the development of the human rights instruments after World War II. But these elements developed then slowly and have led us to where we are today and have sort of given us the legal order that we are familiar with in the Western legal tradition today. And as we see then, having developed over time, they are deeply embedded into our legal tradition, into our institutions, into our frame set, way of mind, and so on. Now, this looks very good. And of course, one element of this is that law curbs power. And that if there is a development of authoritarian rule, this authoritarian rule will be kept in check by the legal institutions and by the law. However, throughout history, we see that this is not the case empirically. There are, of course, instances where authoritarian rulers break with this tradition and are able to break with this tradition. So the Western legal tradition is no type of vaccination or inoculation against authoritarian power. We can look at some well-known examples from the 20th century. We have examples today in sort of the rule of law backsliding also within Europe, but I'm not going to talk about that. I'm going to talk about examples that are much more clear-cut of development of authoritarian rules within the Western legal tradition within the 20th century. My first example is to go to South Africa. South Africa has a legal system that is based on the common law, the English legal system. The courts and the bar are modeled upon the English precedent and the English example. And also they have important elements of continental European law through the Dutch influence. And the courts and the legal system in South Africa functioned much in the same way as the courts and the legal system in England and in the Netherlands. Despite this, we had the development of apartheid in South Africa from the 1950s on, and through the 1960s, also the development of a politically very oppressive state. Some have said that the state even developed totalitarian traits with a possibility to suppress all opposition. One thing was, of course, the racial laws, which departed from any notion of equality before the law, but also the oppression of political opposition, which was in the ideology of the fight against communism. All opposition against the apartheid state was seen as communism. And the state reacted then by giving itself powers to departing from the habeas corpus principle by imprisoning people, keeping people without access to courts for months at the time, draconic measures and powers to the security police and so on. After the fall of apartheid, there was the Truth and Reconciliation Commission in South Africa, led by Bishop Desmond Tutu. And one of the elements that the Truth and Reconciliation Commission looked into was the workings of the courts, because the courts had, through this time, functioned as independent courts embedded within the common law and the English legal system. And they were subject to high criticism by Desmond Tutu and his commission in the report that they wrote after looking into the legal system. And they said, among other things, this as their conclusions: the courts and the organized legal profession generally and subconsciously or unwittingly connived in the legislative and the executive pursuit of injustice. Perhaps the most common form of subservience can be captured in the maxim qui tacet consentire, silence gives consent. So the courts and the judges, they consented to the excesses of the totalitarian oppression of opposition by the regime. They denied people the right to access of court. They denied looking into the workings of the security police. They closed their eyes to it. And they did not protect the population against the executive power. So they departed also then from the basic elements of the Western legal tradition, as I explained earlier. Another example is the military dictatorship in Chile, which, as you probably know, was the result of a military coup against the elected government, the socialist government of Salvador Allende. Immediately after the taking of power, political opponents were arrested and interned. Many led to disappearance, many kept in internment for and subject to torture and other forms of oppression by the government. This was contrary to the law, of course. The law gave a right to a review of the actions by the government. And the courts were not taken over by Pinochet and his generals. The courts in Chile, up to this time, had been recognized as the most advanced and the most independent legal institutions in South America, built on the traditions of continental law of Europe. So even though it was a Latin American state, it was deeply embedded in the Western legal tradition. And the judiciary then disciplined themselves. They exercised self-discipline in not interfering with the workings and doings of the military government. Also in Chile, there was a Truth and Reconciliation Commission after the fall of the military dictatorship. And also in Chile then, the commission looked into the working of the legal institutions. And in the conclusion, or in the view of the commission, the judiciary, which in the view of the constitution, the law, and the nature of its functions, was the government institution called to protect those rights, failed by not acting more forcefully. The country was surprised to see the courts take such a stance, for it was accustomed to regard the judiciary as a staunch defender of the rule of law. So virtually overnight, the judicial system turned from being a staunch defender of the rule of law to being complicit with the excesses of the political repression of the military dictatorship. Another example, which I'm going to talk about in the next lecture, is the legal order of the Nazi state from 1933 to 1945. Within these few years, the court system developed from being sort of a paragon and an example of a rule of law state to becoming what was characterized during one of the Nuremberg trials against leaders of the legal German Nazi legal system. The chief prosecutor said that the leaders of the German judicial system consciously and deliberately suppressed the law, engaged in an unholy masquerade of brutish tyranny disguised as justice, and converted the German judicial system to an engine of despotism, conquest, pillage, and slaughter. Now, these are examples, 3 examples, one could mention many more, of transitions quite rapid transitions from a rule of law situation to a total breakdown of the rule of law, at least in a total breakdown when it comes to controlling the excesses of an authoritarian government and the government's use of oppressive means against its population. We can see this if we look into the rule of law indexes, or we have different types of rule of law indexes, but if we follow them, we can see this is how the developments in Germany is characterized. We see here, coming from quite a high point on the rule of law index up to 1933, and a total breakdown in 1933, and then a rebuilding after the rebuilding of Germany after the Second World War. So we see these rapid changes, dramatic changes. We see the same if we look at Italy and France. The red curve here is Italy, with the emergence of Mussolini's fascist government. We see the same rapid decline, fall of protection of the rules of law, and then a rapid build up again and return to the Western legal tradition after the fall of Mussolini after the war. Also in France, with the Vichy government that was in place, where the Vichy government administered the courts in France, both in the parts of France that were not under German occupation, where they had the civil government, but also in the part of France that were under German occupation. The Vichy administered the judicial system in all of France. And we see also here the rapid decline with the enter of the authoritarian government, and the rapid return again to a rule of law situation after the situation had stabilized. Brazil and Chile. I mentioned Chile. We had military dictatorships in several of the Latin American countries, and even though they have started at a lower point on the rule of law index, we see the same developments here with the enter of the military dictatorships. Here is Chile, as I said, having a court system that was recognized as the most advanced on the rule of law index in Latin America before the military dictatorship, the rapid decline under Pinochet, and the return then after the return of democracy in Chile, and the same development also in Brazil. Brazil is struggling now with the Bolsonaro government, of course, and is in a similar type of situation as we have in countries in Europe, if we look at the present situation. Now, what does this tell us? This tells us something interesting about the Western legal tradition and about the relationship between law and autocratic governance. Even though the ideal is within the Western legal tradition that law shall protect us and curb the government, keep the government under judicial control, independent judicial control, we see that these controls break down under certain circumstances. And what we're going to talk about in these lectures is more detailed how they break down, and give some look at two examples. As I said, at Nazi Germany, we'll look at that more closely, and the communist dictatorship in the Soviet Union and in Eastern Europe after the Second World War. But before we do that, we have to look at some traits of the Western legal system that form the background for these developments and make them possible. If we look at law as we define it within our legal tradition, we see that there is a dual nature within our legal tradition, which is symbolized by the sword and the scales in this portrait of the goddess of justice that you see. We have different visualizations of the law and the Western tradition. The top one, we see the codification, we see legal positivism, where the sword has been, or the scales have been substituted for by the book, the Code Civil, le droit, as it says. But the sword is still there. You don't see it so well in this picture. But this symbolizes the dual nature of law. We have the rationality side of the law, or the reason side of the law, or the justice side of the law, symbolized by the book, the scales, balancing, giving justice. And then we have the force side of the law, the authority side of the law, symbolized with a sword, which is the force of the government. And this, of course, is a dual nature. Law is both reason and authority. It's both rationality and force. It's both justice and cutting through, ending argument, enforcing the power of the state. And this dual nature of the law, as we see it, is also in play when authoritarian governments emerge and break through in the law. One theory about this, which was developed during the Nazi time, was the theory of the dual state, developed by the German lawyer and social scientist Ernst Fraenkek. Ernst Fraenkek was born in the German Reich in 1898. He was a soldier during World War I. As you see from his age, he was 20 when World War I was over. So he fought in the First World War for Germany from 1916 to 1918. In 1921, he became a member of the Social Democratic Party within the Weimar Republic. He studied law and took his second state exam in Germany in 1925, and he entered law practice in 1926. And he was a practicing lawyer within the German legal system until 1938. Fraenkek was of Jewish origin, so as you can imagine, he encountered problems when the Nazis took over power in 1933. Now, he was a privileged Jew, according to the Nazi ideology, because he had been fighting for Germany during World War I. So he was a war veteran. And war veterans were given privileges, even though they were Jewish, in the initial years of the Nazi rule. So he was allowed to continue his law practice, albeit restricted to certain courts and certain types of clients, until 1938, when the policy against the Jews changed and all Jews were included in the oppression, also those who had been then war veterans. So in 1938, he had to flee Germany. He emigrated and sought asylum in the United States, where he was given asylum, and he started working then as an academic and a social scientist in the United States, and he became then a well-known political scientist after the war, during the war and after the war. Now, his experience with the bar as a practicing lawyer in the Nazi Germany gave him, of course, a unique outpost and unique viewpoint to look at the legal developments within the Nazi state. And this is what he then summarized and wrote down in his book that he published in 1941 in the United States, called The Dual State. Now, what was the dual state? Well, the dual state was, according to Fraenkek, the way law developed within Nazi Germany, within the so-called Third Reich. He based his studies on the laws that were developed because the Nazi state had an important legislative activity. He based it on court cases, on discussions in legal journals, and on his own experience defending critics of the Nazi regime. And according to Fraenkek, what developed was both a continuity and a discontinuity within law, within the Third Reich. We had what he called the normative state, which was the continuity of law within the Nazi state. And in many fields, law continued more or less in the same way as it had. Of course, the content of the law changed, the methodology developed, and the ideology and the program of the Nazi Party became an important source for interpreting the laws. But still, there was a continuity in the way of thinking and in the minds and in legal education and so on. On the other hand, we had the development of what he called the prerogative state. Now, the prerogative state, that was the SS and the Gestapo and the politics, the Nazi politics. The prerogative state was the ruling by fiat and the ruling by decree, unbridled and unchecked by the law. He said, we have a prerogative state in different measures in all legal orders within the Western legal order. We have some part of a prerogative given to the state and politics also in normal situations. But what happened then in Nazi Germany was the expanse of the prerogative state on behalf of the normative state. And even more importantly, the determination of the limits of the prerogative state was left to the prerogative state. The prerogative state itself defined its competence, an area of competence, and could not be checked by the normative state or by the law or by the courts. So this meant that in areas where there was a conflict between the prerogative state and the normative state, the prerogative state prevailed, and the prerogative state defined, so to say, the scope of its own workings. The normative state continues, as I said, more or less in the same way, but the prerogative state intervened, and large areas of oppression were removed from the jurisdiction of the courts, notably the workings of the Gestapo, the political and secret police, the working of the SS, and thereby the concentration camps, and later the extermination camps, and also the workings of the SS then in the extermination of Jews and others and the Holocaust. So the whole excesses of the Nazi regime that have been that we sort of connect with the Nazi regime now were outside the scope of the law and within the domain of the prerogative state. But the important thing then, according to Fraenkek, was that there was both a break and a continuity. The break was the development of the prerogative state and the giving of competence to define the jurisdiction of the prerogative state and thereby also of the normative state to the prerogative state. That was a clear break, a revolution that took place within the field of law. But there was also continuity, maintaining then judicial independence, legal reasoning, development of use of the old laws and so on within the Nazi state. So what is then the concept of the dual state? It's a particular type of organization of the relationship between law and force. It's important to stress that there is a continuation, a continuity of the normative state. So it's not a total break. The legal autonomy within the normative state continues in a sense. It is challenged, it is changed, and the judges and the legal institutions and the legal actors, their conditions have changed. But there is also continuity in legal autonomy and judicial independence. There's a presumption of jurisdiction with the normative state. So when a case is brought, the presumption is that the courts can deal with it. But the prerogative state can always intervene. The jurisdiction over jurisdiction is with the prerogative state. So this is the important part of relationship. So it's a complex relationship, and we'll see this in play when we look at the Nazi state in the next lecture. And we will also see it when we compare the Nazi state and the communist relation to law, because here we have differences, particularly in this type of organization of relationship between law and force. We also see that if we look at the developments and the current developments, if we take a small look at the situation also after these historical examples that I will mention, the persistence of the normative state does not mean that all use of force is regulated by law. We see that the dual state enters. So it's not only the duality of force and reason, which we see when we look at the superficial picture of the goddess of justice. But even though we have a normative state and we have a strong element of a normative state, as we have in our societies today, in the words of another German political scientist and lawyer who emigrated to the United States during the war, each society has such islands where the rule of law is at best uncertain, conjectural, and often non-existent. So the theory of the dual state makes it possible for us also to search for such islands of the prerogative state within our own legal orders, within our current legal order. So what we want to find then, and what we want to answer is, when and how do such islands of uncertainty expand? And what are the conditions? Because the rule of law and the Western legal tradition does not necessarily defend us from this type of expansions, because these pockets of prerogative state exist within any legal order, also the legal orders truly embedded within the Western legal tradition. And that also means that history does not determine the future, but it influences the way that law is dominated by force. So the development of the dual state and the different developments of the normative state and the prerogative state can explain the specific types of autocracies that can develop easily within countries that are embedded within the Western legal tradition. The dual state is a theory that fits countries within the Western legal tradition and can show their paths into authoritarianism, can show how even these countries can develop into authoritarian rule. It's not a theory that fits equally well to any autocratic rule and any legal tradition. It's developed particularly then to explain and analyze countries of the Western legal tradition. It also shows us then that legal institutions and that legal autonomy prevails is not a protection necessarily against the development of authoritarian rule. And this is the subject then of the next lecture that we will look into, when we look into the development and look more closely at the historical development of the law and oppression in Germany in the transition from the Weimar Republic and into the Nazi rule. But that's a topic for the next lecture. So I thank you for the attention now and end this lecture. Thank you very much.